Welcome to another edition of Disability Insurance Law TV. My name is Gregory Dell. I'm an attorney with the law firm of attorneys Dell and Schaefer, and today I'm joined by Cesar Gavidia. And we are long-term disability insurance attorneys, and today we are going to discuss Mass Mutual Life Insurance Company and how they handle their long-term disability insurance claims. And we're going to look at some cases that our firm has handled, as well as some cases that have been handled around the country and been litigated after some claim denials. And Cesar, I think you have a case that dealt with someone in the financial industry that you researched, in which their claim was litigated. Could you talk about that for a little bit?
Sure. Greg, this case was actually out of the federal courts up in Illinois, and we've litigated cases up there in the past, you and I. But this particular case, this insured was a pit trader for ING. And he was insured under a private disability insurance policy with Massachusetts Mutual. And in July 2002, he was working for ING Incorporated. They had a branch up there, and the branch closed in July 2002. At that point, he went from becoming a basic pit trader, which stands on the floor. I think he was working at the Chicago Board of Options Exchange, standing on the floor, running the trades, doing whatever it is that he does, but standing for long periods of time. He changed from doing that to becoming a computer trader, basically staying at home, you know, doing all the trades by the internet or and through his computer. Well, in December 2002, he becomes disabled from hip pain and hip complications, which basically prevented him from standing for long periods of time and doing the essential duties of what a pit trader does. He applied for long-term disability benefits with Mass Mutual. They denied his claim, stating that he wasn't disabled from computer trading because that is what they found him doing at the time he claimed disability. Well, he sues Massachusetts Mutual in federal court up in Illinois. The insurance company, Mass Mutual, moves for summary judgment, basically trying to dispose of the case before trial, saying, well, we did the right thing because this individual was working as a computer trader and he's not disabled from computer trading, he's claiming he's disabled from pit trading. Well, the judge in this case really didn't give it much weight to that argument that the case should be disposed of at that point. Basically said there's enough evidence here that he was still employed, or his occupation could be considered that of a pit trader, and this case should move on to trial based on the evidence that they presented. The judge also, Mass Mutual actually also ruled to dispose of the case, saying that the individual was not under a doctor's care, under the regular care of a physician at the time he became disabled. But the judge in this case found that the language in this Mass Mutual policy was actually ambiguous regarding doctor's care, didn't refer to when before his disability he had to be under the care of a doctor.
So, but in your case, so there was a big issue disputing what the pre-disability duties were of the claimant, correct?
Right, right.
And so he was saying that he was actually on the pits as a trader, and that should be his pre-disability duties.
Right, standing as opposed to sitting at home at a desk doing the trading online. He just happened to be in that position because the doors closed at ING, and that's what he had to resort to. But the reality is he probably always intended to go back to pit trading before that point.
And so what was the end result of that case?
Well, the end result's still in litigation. And
okay.
I was going back to dates in 2002, and that should just give people perspective sometimes how long these cases can take.
So it's still going on?
Yeah.
Okay. I find often with Mass Mutual that I shouldn't necessarily say often, but the claims that we get that are disputed are mostly not doing a great job of determining what the pre-disability duties are. And we've seen some cases where even after they've been paying benefits for 8 or 10 years, they'll come back and say, well, we think the person can work. Well, 8 to 10 years later, we'll say, well, what do you think the pre-disability duties were? And it's not always what Mass Mutual thinks it was. And I've seen that happen before with an OBGYN that we've represented. I've seen it happen before with a chiropractor that we've represented. And I've also seen it happen again with an internal medicine doctor that we represented, where they're paying for 10 years. There's really not a lot of questions asked about the claim. And then all of a sudden they say, well, we're not really sure what the pre-disability duties are, and based upon what the restrictions and limitations are now on the claim, we think at least they can go back to some kind of work. Now, a lot of the different policyholders that we work with have what are called own occupation disability riders or disability policies. And Mass Mutual really has more of what is a loss of income disability policy as opposed to a true own occupation disability policy. As you know, Cesar, in most own occupation policies, it doesn't really matter if you have a loss of income, it's just that you can't do the material duties of your pre-disability occupation.
Right.
In the Mass Mutual policy, which I pulled one, how they define disability without any riders or anything, and we'll go ahead and put this image up on the screen to show the definition of disability, and I'll go ahead and read it. Disability is the incapacity of the insured, which is 1, due to injury or sickness, 2, begins while the policy is in force, 3, requires the care of a physician, and 4, which I think is the little bit unusual definition, reduces the insured's ability to work, and 5, causes a loss of earned income, and they define earned income. Well, 2 definitions in this policy, which you know are unusual, reduces the insured's ability to work. You know, what does that mean? That sounds like a pretty liberal definition, meaning pro-claimant. Right. And then number 5, causes a loss of earned income. Well, if you have to have a loss of earned income, then that means that it's not just about you being unable to do the duties of your occupation. You could technically be able to do some other job, but if you end up having a loss of earned income, not having loss of earned income, then you're not disabled. So you want to be really careful with these Mass Mutual policies, because you could be disabled, not able to do duties of your occupation, but somehow or another do some other occupation and end up making a lot of money but not be disabled. Right. So now obviously they do sell own occupation riders and things like that, but even with some of their own occupation riders, I've still seen them where they're tied into income. So, you know, it's hard for us to go into specifics in this limited time period, so certainly if someone has a question about this, they should call us. I've also seen, to talk a little bit specific about Mass Mutual, they used to do a lifetime benefit rider, and now they have one of those scaled down lifetime benefit riders where, you know, when you turn age 55, you get 90% of the benefit after you turn 65, and then 80% of the benefit after age 65.
It gradually reduces.
It gradually reduces down, but it's still nice that they offer that type of lifetime benefit. And then there's also issues about, since they're so tied into income, whether it's income, and we've argued this a lot, whether it's income if you're still an owner in a business that from work that other people are doing. For example, you know, if you're a doctor in a practice, but you're an owner and you have 3 or 4 other physicians in your practice, but now you're not working, but those other doctors are generating significant revenues for the practice and you're still making money, but it's not the services you perform. For example, in this other policy that I mentioned just a few minutes ago, which we can put back up on the screen for you, it says earned income for any period of time is the income earned by the insured, whether received or not, for services performed during that period. So the key is that services performed. Really, the only income that should be considered is the services performed by the claimant. So if you're still an owner in the business and your business is still making money, but you're not generating any of it, then the reported income to the company should be 0 for you, right, and 100% for all those other people.
And the intent when most people buy these policies is that they're insuring themselves and their ability to do the work themselves, not the ability of everybody else to do the work for them and generate the income for them.
Right. So we've represented numerous clients, especially with Mass Mutual claims, where Mass Mutual was trying to refer to the income of the practice, right, and not specifically looking at the services performed. So that's an important argument. It's something that you should be aware of if you have one of these policies. On behalf of myself and attorney Cesar Gavidia, we want to thank you for watching this video. If at any time you have any questions about a Mass Mutual long-term disability policy or any other long-term disability insurance policy, feel free to call us at your convenience.